All right, good morning and welcome everyone to our Q&A session on Law of Contract 1, which is the foundational course on contract, covering basically the basics of contract law. So I really wanted to give you an opportunity today to just ask any questions that you might still have, and the way I suggested doing this is I'll just go through the 7 areas that we covered on this course and kind of recapping those, and any questions that you have, you just post them in the chat board, or some people have emailed 1 or 2 questions, so I will cover those as we kind of go along and try and make reference to those as we go along, as we go through the various topics. So let's start then with our first topic. So remember, we had 7 topics on this course, and 4 of the topics were basically asking as to whether there was a contract in existence, whether there was a contract in the first place. So offer, acceptance, consideration, intention. Those 4, you always have to go through those motions, tick those 4 boxes, figure out whether you have those 4 in place in determining whether there even is a contract. So those were the first 4 topics on this course. And then subsequently there were 3 further topics on this course, which we will also look at. And they were kind of more to do with what's in the contract, who can sue upon the contract, and so on. So that all obviously comes after we figured out whether or not there is a contract in the first place. And those topics were privity, the question of who can sue, and then terms of the contract, so what's in the contract, as well as exclusion clauses, which is really just a special form of a contractual term. So those 7 are the topics of the course. That's it. So let's go through those 7 in order, and then as I said, as we go along, just post your questions on the chat board, and I will address them as we go along. And then someone, for instance, asked something about consideration, so I will address those points as we go through that particular topic. So offer was our first topic, and it makes sense because that's what you need to have. That's the very first thing you need in order to have a contract. And offers are very kind of easy to trace in the sense of having a checklist. Checklists are nice because, especially in an exam and a sort of high pressure situation, if we remember there's a checklist, if we remember there's certain boxes we have to tick, and we can sort of do that in a mathematical kind of way, where we just go, or a methodical way, like, okay, we got this, we don't have that, whichever it is, that makes it a lot easier, and makes sure that you don't sort of forget something sort of in the heat of the moment. So we need 4 things to have a contract. Okay, we just talked about that, and we're going to go through those 4. So the first of those is offer. Now within the area of offer, again, we're looking for 4 things. This is a coincidence that it's 4 as well. So we need to look at 4 different aspects of say, for instance, a factual scenario, in order to determine whether there is a valid offer. And those 4 are, first of all, we need to know who the parties are. So we need to know who's on the one side of the contract, who's on the other side of the contract. Secondly, we need to know what the subject matter of the contract is. In other words, what's the promise being made? Is it a car being sold? Is it a machine that's being lent out? Whatever it is, what's the promise at issue, the subject matter? Thirdly, we need to know what's the reciprocation. So what is being given in return for that promise? Now we could look at that as another promise, so a promise in return for a promise. So in essence, subject matter and reciprocation are the promises involved. Promise from party A, promise from party B. And lastly, we need to know what the time frame is. So sometimes we don't really need to go and check that 4th point, because if you go to the supermarket and buy something, obviously you're entering into a contract, and the time frame is clear. You don't have to tell the supermarket, and I'm now going to take these goods and take them home with me. That goes without saying. That's obvious in that scenario. But in other scenarios, say if you bought a car or something kind of bigger, there might be a question of time in terms of when do I take possession, when do I have to pay, those sorts of things. So those are the 4 things: parties, subject matter, reciprocation, time, that we need to know whenever we figure out whether or not there is a contract. So that's very simple. So when you come across a scenario and the first question you ask, is there a contract? You look at, is there an offer? The first of the 4. Within that, you look again at those 4 criteria. and that should then hopefully give you the answer. Now, sometimes there might not be all four in place, and we all remember a very, very famous case, the Jamaican case of Harvey and Facey. That kind of, there was some telegrams sent back and forth, and I'm sure you've all had a look at that again. Very important case. And remember, although if you sort of look at all the telegrams, it kind of looks like maybe these people have entered into a contract, and certainly maybe at least there's an offer in place, you would have noticed there's something missing. If you look at the subject matter, okay, it's there. It's a sale of a property. Reciprocation is there. There's a sort of a monetary amount that's mentioned. Time frame, we could perhaps argue about. But one thing that is definitely not there, that's just very clear, is that it's not clear who the parties are. Now, it might look like it's Harvey on the one hand, Facey on the other hand, but remember, the seller never says that they will sell to the buyer. So the buyer at all times is just a person who is interested, but the seller never says, okay, I make this offer to the buyer, which is very, very important because you need to know who the parties are. And one of the reasons you need to know this, which is kind of very important to kind of conceptually grasp this, is if you put out an ad, like let's say you're selling your laptop secondhand or whatever, you put a little notice on one of the boards. You are not, by doing that, you're not saying that you will sell to anyone who comes forward. Maybe someone comes forward and you don't like that person, so you don't want to sell to that person. So you shouldn't have to sell to that person. That's why your ad wasn't an offer in the first place, because in order for it to have been an offer, it would have had to have determined at that point already who is the seller, who is the buyer. And we don't know who the buyer is at that point, so it doesn't work. So these are the four criteria as to whether there's an offer. Now, again, normally that would be sort of fairly straightforward, but as always in life, there's sort of certain complications that come along. We all remember the very famous case of Carlyle and the Carbolic Smoke Ball Company, where a particular type of complication came along, which was the fact that there was an ad, so kind of keeping with that example, and the ad told people to buy a certain medicine, a drug, the smoke ball, and if they did that and if they used it in a certain way, then they wouldn't get sick, they wouldn't get influenza. And someone did that, Mrs. Carlyle did that, and she did get sick. So she wanted to claim the compensation, the reward that was offered in the ad. Now, one of the arguments put forward by the Carbolic Smoke Ball Company as to why they didn't want to part with the reward money, which is £100, which back then was, of course, a huge amount of money, was that their ad wasn't an offer in the first place because it hadn't determined who the buyer and the seller, or who the two parties in this case were. And normally that would have been an argument that would have basically determined the situation, because it was clear that the Carbolic Smoke Ball Company was one of the parties, but it was not clear who the other party might be, because again, it was an ad that was in a paper, and anyone could have seen the ad, anyone could have been the other party, but that was not determined. The court sort of carved out a little exception here, which they called a unilateral offer. And the reason that we had the unilateral offer here was because it's not really an exception in a sense. If you think about it, yes, the Carbolic Smoke Ball Company is one of the parties to the offer. Who's the other? Well, we don't know that yet definitively, but as soon as someone does all the things as described in the ad, they sort of crystallize. It becomes clear who the other party is. So anyone, by putting out the ad, anyone who does all the things that the ad mentions becomes the other party. So that's kind of a bit of a special case where we still have an offer, even though at the time that the ostensible offer is made, it may not have been clear who party B, who the other party is. But as I said, that can be overcome by thinking of it in the sense that the ad was clear enough to make it determinative, in the sense that it was possible for Mrs. Carlyle or anyone else to do all the things that were mentioned in the ad without any further part being played by the Carbolic Smoke Ball Company. So in a sense, there was another party. It's just the Carbolic Smoke Ball Company didn't know their name, but they put out enough criteria for that other party to crystallize. If, on the other hand, so if we look at, for instance, the usual type of advertisement like Partridge and Crittenden, we had that case. You put out an ad for the sale of wild birds or whatever it might be, or we had the case of the wine that was being sold. It's so many different. Basically, you open the paper, any kind of ad where something's being sold. Now, in those cases, the ad itself doesn't give you enough information so that party B crystallizes it, because at any moment in time, party B still has to go to the shop and still has to sort of present themselves. And party A can still decide whether they want to sell to this person or not. Whereas in Carbolic Smoke Ball Company, that's not necessary, because by doing all the things mentioned in the ad, Mrs. Carlyle satisfied not only the fact that the ad was an offer in that case, but also satisfied the consideration requirement, which we'll come back to later. All right, we had a question there about frustration. Maybe we can come back to that later. Let me just stick with offer at the moment, and then just kind of try and go through it. And as we go through the topics, I'll address the various questions that come up. So, offer, we need to look for those four things. We know there are some sort of specialized rules, might say exceptional, but if you really think about it, it's not really exceptional. So Carlyle isn't really exceptional at all for the reasons that we just discussed. The other say, again, it's not really exceptional, these other special scenarios or specific scenarios such as ads that we just had. So normally ads are not offers for the reasons we discussed. In Carlyle, very exceptionally they were, but again, exceptionally only in the sense that it doesn't happen much. The only other scenario that we discussed and we can sort of think of is the lost and found ad. So you put up an ad, I lost my iPad, anyone who returns it, you get $100 or whatever. Well, again, the person who returns it can crystallize themselves just by doing exactly what you ask them to do. And there's no role for you to play beyond putting out the ad. So those are the unilateral offers. Other than that, advertisements are invitations to treat. They're not offers. Shop displays are essentially Fisher & Bell, remember the flick knife. Those are, again, essentially they're ads. They're just ads in a different form. Instead of in a paper, they're ads in a shop that you kind of walk past. And then we had auctions and tenders, some specialized rules of that. So have a look at that, or ask any questions if you have them now in relation to that. And then I think the only other thing we need to know about offers is how do offers come to an end. So the kind of the risky part, I suppose, with an offer is if you put it out and if there is if there's another party that is determined, so your party A, you put out an offer, the offer is for party B, a specific person, then the offer kind of hangs around until party B decides to either accept or not accept. So does it hang around forever? No, obviously you can withdraw it. So that's the most easy way of sort of getting rid of your offer. If you don't want to have that offer out there anymore, you just withdraw it. The other way is if the other party rejects it. So if the other party says, no, I don't want that, or it's too much, or whatever it is, as soon as the other party rejects the offer is gone. The offers can also terminate through lapse of time or through death. So lapse of time would be just an offer won't hang around for weeks and months and on end. At some point, and we discussed this at where exactly that point is, it really depends on the situation, on the type of subject matter at issue. So some offers, say, if you were buying and selling stocks, which are very time sensitive, the offer might lapse very quickly just by the passage of time. Other offers, maybe if you put out an offer for someone to buy your house, that might hang around for a bit longer because you need a bit more time to sort of figure out whether you want to go ahead with that. So that, in essence, is what we covered under the topic of offer. I see we have a question about intention to create legal relations. That's great. I will come back to that question when we get to that's the fourth topic. So when we get there, I'll talk about that case. So offer number one, number two, acceptance. So acceptance is really sort of the other side of the coin of offer, and they really go hand in hand, those two topics. Now, if you have an offer, you then need to satisfy those four criteria that we just talked about. Acceptance, on the other hand, is very simple. Acceptance is just saying yes, or I agree, or I accept, or words to that effect. And the acceptance must be unqualified. So as soon as you say something like, I agree, but, or could we change the price, or if you say anything that's qualified anyway, then it's not acceptance. So acceptance literally has to be I agree, or I accept, or something to that effect. Now, we found out that you can agree or accept by your conduct, for instance, by nodding your head. Then you don't utter any words, you just nod your head, but that's acceptance. You can also accept by doing what has been set out in the offer. So that would be another form of acceptance by conduct. So all of that is possible, but the main point about acceptance is that it has to be unqualified. So no more discussions, no more negotiations, nothing like that. In essence, whatever way you express it, it has to be an expression of agreement. I agree. Those two words suffice. So that's really, in essence, the juice of acceptance lies in the offer, because if we have the four elements of the offer in place, then all you do need is to say yes, or I agree, and that then suffices. So there's only a few rules that sort of we need to know beyond that, beyond the basic concept that acceptance is just the utterance of very clear words such as I accept, which is in essence has to do with the communication. So you can nod your head, or you can say I accept. So and that would then be acceptance. The only question then that remains is, has the other person received your acceptance? So if you are standing in front of them and you utter those words, essentially the sound waves coming out of your mouth have to reach the other person, which in face to face would be more or less instantaneously. It gets a bit more difficult when, for instance, we're on the phone with someone. When does the acceptance reach the other side? Well, the signal has to travel through the copper wires and eventually end up on the other side's phone. And as soon as it comes out of their speaker on their phone and they hear it, then the acceptance is valid because it's received. So that's the receipt rule. And we had a case which was Entor's and Miles Far East. There was other cases too, but that's the default rule. So if there's no other kind of special rule that we need to use, and we'll get to those in a moment, we just use receipt. Did the other person receive the acceptance? That's the receipt rule. So there's two kind of exceptional circumstances that deviate from the receipt rule. There's only two. So again, very simple. The first one is, what if you post a letter? Now, normally, if we apply the receipt rule, posting a letter would mean that the letter has to be picked up by the postman from the post box and go through the postal system and actually be delivered to the other side. That's receipt rule. They have received it. But the courts, Adam and Lindsell is our case here, kind of carved out a bit of an exception here, whereby the acceptance is valid not when it's received, but once you post the letter. So you hand it over to the post office or you put it in the post box. At that point, the acceptance is received. Now, why is that? Why did the court sort of carve out a special rule here? Well, it's because the communication is not instantaneous. So it's very difficult. So if you're talking to someone face to face and say, I agree, then you know that the other person heard you. So the person who accepts knows that the offeror has received the acceptance. Or if you're on the phone, you will know that the other person heard you. It's very, very likely that they heard you. But if you post a letter, how do you know that the other person received the letter? And in essence, you then have to apply the risk or assign the risk of the letter not arriving to one of the parties. You assign it either to the offeror or the offeree. And the court held that in this circumstance, it's appropriate that the risk be assigned to the offeror. And the reason essentially is a very simple one. It's not about sort of flipping a coin or whatever. The reason is because the offeror is the person who gets to set the terms. Remember what we just did, the four parts of the offer, which include the terms of the offer. And if you get to set the terms, if you get to say, well, here's my offer, I'm going to offer you to buy this at this price, and you get to set all that, then one of the things you can set is the form of acceptance. So, for instance, if you think doing something by a post is risky as the offeror. You can say, I will not accept letters by post. You got to communicate with me directly, or it's anything like that. So because the offeror is basically the boss who determines these things, the risk of the letter being lost should be assigned to the offeror. Hence, as soon as the offeree posts a letter, puts it in the post box, the contract is formed, and the risk that the letter is lost and never arrives with the offeror, that risk rests with the offeror. So that's an exception to the receipt rule. The other exception to the receipt rule we had was the email rule. And email is kind of a middle thing between having the, talking on the phone to someone where the communication is more or less instantaneous, and the postal rule where you hand over your information to a third person. So it's kind of a middle thing, because what happens is in the postal system, you give it to a post office, the US Postal Service or whatever, and then they will deliver it and it will stay within that system. Or if it goes international, it will go to another post office. But again, then you're only dealing really with two parties, and it sort of stays within the postal system. Email is far more difficult, and I'm not going to get into the details of all that here, but you have different providers, and you have the ISPs, and you have the, there's so many different stages, so the rules had to be kind of adapted to that. So remember, the rule is, as soon, and this is done by way of legislation, as soon as the email message or the internet message arrives at the offeror's server. So not as soon as you press send as the offeree. So when you accept and press send, that's not the point of acceptance. That would be Adam and Lindsay, that would be postal rule. It's not that. It's not when it arrives at the other guy's computer, at the offeror's computer. That's sort of too late. It's kind of in between, when it arrives at their server. So that's the email rule. But the basic rule is the fact that the receipt rule is the default rule. It's done by way of whenever the acceptance is received by the other party, by the offeror, that's when the contract is formed, because at that point you have offer and acceptance. All right, we have a few more questions here. So we have a question on New Zealand shipping. Okay, we'll get to that. We have a question on consideration, forbearance, Alliance Bank. Okay, we'll get to that. And Privity. Okay, so we will get to all those. I see we have a lot more to go in the other topics, especially consideration. So let's move on to consideration. Consideration is essentially what you have to give in return for a promise. So you go and someone makes a promise. You go and buy something, or you buy a car or whatever, and the promise might be, I will give you my car if you give me so much money. Then the consideration would be the amount of money you give. So the underlying idea of consideration is that every contract needs to be part of a bargain, and bargain in this sense means each party has to give something. One person makes a promise and someone else the other party gives something else in return. That's the essential idea of a contract, and hence consideration is that which you give in return. So the easy part, I want to get to these more difficult cases. The easy part is that what we call consideration has to be something of value in the eyes of the law. That's the definition of it, Curry and Misa. What is something of value in the eyes of the law? Well, two criteria. It has to be measurable, number one, and it has to be sufficient but not necessarily adequate. So there need not be any adequacy, but it does need to be measurable. Measurable basically means it has to have some sort of economic value. So we have the case of Chappell and Nestle, where we had, for instance, the chocolate wrapper, remember, which was deemed to have an economic value. To most people, it's just a chocolate wrapper. You throw it away. That's it. But in the eyes of the law, that has economic value. So have a look at that again, Chappell and Nestle, or ask any questions if you have them. Don't see any questions out right now. All right. The other point about the adequacy is equally important, which is that whatever you give in return doesn't have to be a fair value. It doesn't have to represent the actual value of the promise you get. It could be anything. So the whole idea, Thomas and Thomas, for instance, that you can get a whole big chunk of land and rent that, lease that for a whole year just for £1. Okay, obviously the £1 is not a fair value, it's far too little. But the court doesn't concern itself with that, as long as you have given something of economic value. Okay, so those are the basics of consideration. That's very easy. Now let's get into some of the more difficult points on consideration. So we have a question on forbearance to sue can constitute consideration. Yes, this is very true. So if you have someone who said, if you have a contract between someone and, for instance, there's some disagreement, and you say, I will not sue if you do such and such. And later on, the person who was supposed to do such and such doesn't do it. Then you, who went suing, you can say, well, actually, if the other person says there's no consideration, there's no contract, you can say there is consideration because I could have sued you, but my consideration, what I gave for your promise of whatever you were going to give me, what I gave in return was my promise not to sue you. So it just illustrates that the even something very abstract like forbearance to sue, very, very abstract thing, can be valid, good consideration. A great case for illustrating the concept of an abstract consideration. So normally we would consider illustration as something such as money. Money is very, very common consideration. So you buy something, you give money, or you provide a service or something to that effect. So these are not abstract things. Those are very, very obvious what they are. Abstract things are again, we had the forbearance to sue. I think a great case to illustrate is Bainbridge and Firmston. So Bainbridge had these boilers, these two massive boilers to basically create steam. And Firmston, for whatever reason, wanted to have those boilers, wanted to kind of borrow them. And so they made a deal whereby Bainbridge said, okay, you can have those boilers if you return them in good condition. And Firmston said, okay. So Firmston took them away, but then Firmston brought them back in parts, not in good condition. So then Firmston says, well, we never had a contract because there was no consideration, and hence I didn't have to do anything. This was kind of just a friendly sort of deal that was not a legally binding agreement because there was no consideration. And Bainbridge said, no, there was, because there was an exchange of promises. So in return for taking away, or for being, say, allowed to take away the boilers, the promise, the consideration was to bring them back in good condition, which is, again, it's a very abstract thing. It's not like paying money to take them away. It's not like paying money to borrow them or giving some sort of service or something else in return that's sort of tangible. It's just an abstract thing, but that works just as well. So the idea of someone forbearing to sue is just as much an abstract type of consideration, but it's good consideration. So remember, it's just any sort of detriment suffered by the one of the parties to any sort of forbearance, anything that they might have done but didn't do. So and of course, having to put machines back together is a detriment. Is not being able to sue someone because you sort of forwent that right when you had it is something that you could have done. It's a detriment to you. So any kind of detriment would usually suffice to be good consideration. Let me see what else we have on consideration. We have questions on Privity, intention, New Zealand shipping. All right, DC builders. All right, very good. New Zealand shipping is a very special case, probably the most difficult case that we did under this heading of consideration, perhaps even in the whole of foundational contract law of the cases we looked at. The reason why it's sort of a bit difficult to grasp is possibly along the lines of the sort of abstract thinking that we just talked about. So remember, the general rule is for every contract you need to provide something new. You need to provide something in terms of your consideration. If you want a new contract, you need new consideration. So you cannot rely on something you've done in the past or something that you're already bound to do in order to say that you've provided consideration. And that's the general rule, but as always, there are sort of some little tweaks in it. And one of the tweaks is that this general rule does not apply to third parties. Now, before I get to New Zealand shipping, let me just illustrate from a very simple, in terms of a very simple example. So, for instance, we have, let's say I provide teaching, okay? So, I provide teaching, I have an agreement between a student and myself, and there's a contract and they want to know more about some area of law, and we agree that I will tell them more about this area of law. Now, what happens if instead of just that one person being there to listen, so let's say we meet on Skype or even on this kind of YouTube platform, and I say, okay, if you pay me $10, I will explain to you such and such, and you can have a contract. Now, that would be, you would give money, and in return I would give sort of an explanation of some area of law. So we'd have a contract, and that's great. Now, what if I asked, if someone else came along, another student came along and said, I too want to hear about this. And I allowed them to join the same Skype session or the same video conference or the same classroom even, or whatever. So they could sit there too. So suddenly instead of one student, there'd be two students. So that second student would be like a third party in the scenario. Now, what if the second student paid me money as well? So now I'm getting money from two students. But I'm only doing the thing I promised to the first student. I'm only doing it once, right? I'm only explaining things once. It just happens to be two students in front of me instead of one. That's perfectly allowable. So that's, in essence, how the third party issue works in consideration. Just on a very simple, very basic level. So let's have a look at it in respect of New Zealand and Satterthwaite, the Euromedon, okay? Name of the ship. You know, remember we can use the name of the ships if by convention if the case involves those ships. So the Euromedon. So much more complicated, obviously, but in essence, kind of the same scenario. One person does something only once, so the teacher only teaches once, but there's several parties who are paying, several parties involved. And the question is, after the first one pays, does the second have to pay, does the third one have to pay, and so on? Or can I take the payment from the second, third, fourth, or whatever? And the answer is yes. And so in New Zealand shipping, the scenario was that there was a company in England, Satterthwaite, and they shipped some machines over to New Zealand. And in the middle, there was a shipping company, so basically the owners of ships who had the containers on their ships, and they were called Federals, let's just call them Federal Shipping. So Satterthwaite had a contract with Federal to ship those things to New Zealand. That's all that Satterthwaite knew. Now on the other end, when the ship arrived in New Zealand, Federal had a separate contract with a dock company, stevedores, called New Zealand Shipping. That contract was to unload the ship on the New Zealand side. So you had two contracts, but it appeared as if you didn't have a contract between Satterthwaite in England and New Zealand Shipping in New Zealand. These parties didn't even know each other, they never talked to each other, and so on. Now, New Zealand Shipping then damaged those goods as they were unloading them. The question then became whether Satterthwaite could sue both Federal and New Zealand Shipping for the damage caused. Now, clearly, they could have sued, Satterthwaite could have sued Federal because those two had a contract. So they could have sued in contract for basically Federal not keeping its promise. But because Satterthwaite left things too long, the time period for bringing a suit and contract expired. And essentially that meant that they could no longer sue Federal. Now, why? The statutory limitations, we don't have to get into that, but in this case there was a specific clause in the contract between Satterthwaite and Federal that said if anything goes wrong, you get 1 year, or 2 years, I think it was 1 year to sue. Okay, so they went beyond that 1 year, so they could no longer sue Federal. So Satterthwaite said, okay, if we cannot sue Federal, how about let's sue the New Zealand stevedores, and we can sue them in tort. If we sue in tort, we don't need to have a contract. Now, the New Zealand stevedores, New Zealand Shipping, said, no, you cannot sue us because we do have a contract. And our contract also prevents you from suing be after 1 year. So you only get the same 1 year that you get with federal. And so obviously Satterthwaite agreed, and the case sort of went through all the motions. The court in the end held that there was a contract between New Zealand Shipping and Satterthwaite, even though on the surface of it there wasn't. And the essence of there being a contract goes into another case, the Himalaya. We might have a chance to talk about that later. It had to do with agency, whereby the federal, the shipping company, acted as an agent on behalf of New Zealand Shipping. But the significance for consideration, that's more in the area of privity. The significance for consideration is that the court held that the unloading of the ship, so the unloading of the ship in New Zealand by New Zealand Shipping, was the consideration, both in respect of the contract between New Zealand Shipping and Federal. So Federal paid New Zealand Shipping to unload, so the unloading was the consideration, okay, that's clear. But also in respect of the contract between New Zealand Shipping and Satterthwaite. So the unloading, this is what I talked about earlier, the act which you only do once, you only unload once, but you essentially get paid for it, you get consideration from two sides. So the consideration paid by Federal was money. The consideration paid by Satterthwaite was the promise not to sue beyond 1 year. So you have one action and it pays for essentially two contracts. But that's only possible where we have third parties involved. And so in a sense that's a little bit exceptional, because if it was just two parties involved, there's no third party involved, then if you just do what you promised to do anyway, that can never be good consideration for another contract. Then you're just doing what you promised to do under an existing contractual obligation and beyond. All right, so we now have our promissory estoppel as well. Okay, so let's talk about promissory estoppel. So remember in promissory, so we had a question on that. Promissory estoppel is the only true exception to the idea that you always need to provide consideration for any contract. So remember, every contract needs to have those four elements that we talked about. One of them is consideration. So every contract needs consideration. If there's already an existing contract and you want to have a new contract, that means you want something else, or you extract a new promise, or whatever it is, you have to pay for that. Okay, so every single thing you do in terms of reaching an agreement, reaching a contract, if there is going to be a contract, you need to have consideration. The only exception to that is promissory estoppel. And here's how promissory estoppel works. In our cases, Central London Properties and High Trees House. So remember there was a company called Central London Property, and they owned all these blocks of flats and so on. Now it's very difficult for, or so maybe a bit burdensome for a big company like that to deal with all these individual tenants by renting out individually. So what they did instead is Central London Properties let out a block of flats to another company called High Trees House and let them deal with it. So High Trees House paid an amount, I think it was £2,500 or whatever it was, to let those flats, to rent them. Now, once the High Trees House had rented them, they would then basically sublet each individual one of the blocks, each individual apartment to individual tenants. So they sort of dealt with these sort of minutiae. Now that's just a normal contract. There's no problem with that. The problem arose when, after this deal was struck, World War II broke out. And what that meant was that a lot of people, because of all the bombings and so, a lot of people left London, went to the countryside. So High Trees House was not able to fill the flats as anticipated, and obviously they weren't able to generate the rent payments that they had sort of anticipated. So because of all that, Central London Property said, okay, we will take a smaller amount of rent, or we will sort of unilaterally change the terms here. After the war, and then, High Trees House said, that's great, thank you very much. After the war, the question arose as to whether Central London Properties could still claim all the outstanding rent, all the rent that wasn't paid during the war. And normally they could. And the reason is very simple. The promise to accept a lower rent was not supported by consideration. When Central London Properties said, okay, look, it's war, we understand, you can pay half, whatever. at that point, High Tree's House didn't give anything in return. They didn't say, we will, okay, thanks very much. In return for your lovely promise, we will do such and such. They didn't. They just said thank you. So there was no consideration. And yet, even though there was no consideration, so normally, no contract, the court said there is something called promissory estoppel, which actually has been established about 70 or so years before, but never really used until Central London Property. The court said that because it was the amended rent, that offer was intended to be binding. The Central London Property was serious when they made it. And, very importantly, because High Tree's House relied on it, thinking it was serious, that means if they had known it wasn't serious, they might have taken a different course of action. They might have declared bankruptcy. They could have done all kinds of things. They didn't do that because they relied on the promise. So if those kinds of promises are made and the other party relies on it, those promises will be binding, even though there's no consideration. So that, in a nutshell, is promissory estoppel. All right, we have a question on collateral unilateral contract. I think that gets too complex for us here. So we know what a unilateral contract is. We just discussed that earlier. Collateral contract is a contract on the side, sort of a contract that feeds another contract, or the contract that results in another contract. In fact, I think we can, we'll get to that when we talk about privity. So let me get back to collateral contracts later on. Okay, officious bystander test, we'll get to that in a moment. And okay, so we got a number of questions, but not on consideration. So why don't we move on then to the last one? We did have a question on this. So the last of the 4 requirements for whether there even is a contract, the last of the 4 is the intention to create legal relations. So this is actually a very, very simple area. This is probably the most simple of the 4 to establish whether there's a contract. What it basically means is not only do we have to show there's an offer and acceptance and that there's consideration, we also have to show that the parties intended to have legal relations. And the reason why we have this 4th requirement is that often in real life, and I'm sure you even today, just today or any other day, you would have probably had what looks like a contract with a friend of yours or a family member of yours. I will, do the dishes if you cook the meal or whatever. This very sort of simple scenarios that happen every day. Now, in order for that to not result in legal relations, which it ordinarily would, if it was just offer, acceptance, consideration, those would all be contracts. But we don't want, family members suing each other or whatever because, someone didn't do the dishes even though someone else cooked, or whatever the scenarios. Or, we talked about the scenarios like, I will buy you drinks if you buy dinner or whatever. Because we don't want to sort of have, people, members, family members or friends or whatever suing each other. The law presumes that if we are dealing between friends or between family or family and friends, any sort of permutation of that, then there is no intention to create legal relations. So kind of to preserve those kinds of relationships. That presumption can be rebutted. So the usual examples we use is husband and wife. Husband promises something to the wife. Those promises are not enforceable. There was no intention to create legal relations. However, if a couple is legally still married but sort of factually separated, and the husband, we have married, the husband has a girlfriend, and so on and so forth. Well, in those cases, we can rebut that presumption against intention to create legal relations simply because even though they might be married, so technically they're not really friends. They're not really on good terms. So if these two people who are not on good terms kind of interact with each other, make promises to each other, they should be bound. Okay, so Merritt and number of other cases. We had Parker and Clark, Simpkins and Pays, and so on. So have a look at that. But generally, this is a fairly sort of straightforward area of whether or not there's a contract. So the 4th area, intention, is very simple. And in a way, it gets even more simple when you look at businesses, because with businesses, we just assume if businesses have agreements with other businesses, or if there's any sort of commercial business type agreement, even if a consumer buys something in a shop, any sort of thing to do with commercial activities, business, we have an intention that is presumed to be there. We just assume that if you go and buy a product, you intend to create legal relations, as does the shop, or any business dealing with another business. And we have Edwards Skyways kind of we use that as our kind of anchor case on this. Remember, this was the pilot who was let go, and there was sort of a payment was agreed that he would receive that payment, and later on the company said, "Oh, we didn't intend that to be legally binding," and so on. And the court said, "Look, this is a commercial agreement, employment law, in fact, where you agreed to pay this pilot some money, and therefore because this is a commercial agreement in nature, the law assumes that there was intention." Now, again, that intention can be rebutted, so you can rebut it the other way around. But in order to rebut that intention, it has to be very clear right from the outset that the business to business or business to consumer agreement is not one that is legally binding. So, for instance, you had SOSA and the marketing board, where the agreement itself said it is a gentleman's agreement. If it says it's a gentleman's agreement, well, gentleman's agreement by its very nature means that it's not binding. Okay, so that's a way to avoid that on the business side. We had the case someone asked, so this is a good time to get to this, of the Esso Petroleum and the Commissioners of Customs and Excise. Again, the question of whether there was intention to create legal relations. So this agreement, this was about the Esso had a sort of a little campaign during one of the World Cups, where if you filled up your car with at the Esso petrol station, they would give you a little sort of commemorative coin, but it could really be anything, just something sort of a little souvenir or whatever, on top of so you pay, you fill up your car, you pay, and then you get this little souvenir. And the question arose from a tax point of view, which we don't have to get into, whether that souvenir was kind of part of the contract. So whether there was a contract not only for buying the petrol, for buying the gasoline, but also for essentially buying the souvenir. And the court held that there was no intention to create legal relations on the souvenir side, only on the petrol side, because the transaction is really about you buy petrol, you get the souvenir. Sorry, you buy petrol, you pay money. That's the transaction. The souvenir is something on the side. Think of it this way. What if the petrol station has run out of souvenirs? I'm sure you've all kind of experienced that. You've gone to, say there's a promotion at McDonald's or whatever, and you buy the food, you buy the meal, the Happy Meal, whatever it is, and they're supposed to give you some kind of little toy or some kind of souvenir or whatever. And what if they run out of that? Do they have to give it to you? Well, according to Esso Petroleum and Commissioners of Customs and Excise, they don't, because there's no intention to create legal relations on these sort of gimmicky things. That's just something they say, well, we'll give you that for buying the petrol, but the actual contract is about buying the petrol, buying the food or whatever. And then whether they give you that or not, that's sort of more of an honor thing. So no intention to create legal relations with that. All right, I know we have officious bystander questions, so let's try and get to those as we go through, in particular as we get to contractual terms. So next topic is that we did, so we've done 4 now: offer, acceptance, consideration, and intention. And the next topic then is privity. Let me see if we did have a privity question. Okay, so the Lord Reed test, very good. Okay, so let's start just generally with privity, just to get up to speed. Privity is the idea that only parties to a contract can sue upon the contract. Very simple, very straightforward. This goes both for obligations and benefits. Now, obligations is very easy. It's very, very easy to understand. Why? I mean, we can't have a situation where party A and B get together and have an agreement, and by way of their agreement, they impose an obligation on party C, someone else. You can't have that. So it's got to be only party A and B who are privy to the agreement, and then they're the only ones who can sue upon that agreement. So for obligations, it's very commonsensical. For benefits, it wasn't always clear. So if party A and B get together and say we agree that we will both give money to C. So there's a third party, but suddenly the third party doesn't incur an obligation. Suddenly the third party receives a benefit. Should that be enforceable by the third party? So the law wasn't always clear on that until we got to Tweddle and Atkinson, again our landmark case here, our kind of anchor case. And in Tweddle and Atkinson, remember the two fathers, father and father-in-law, both agreed to give the son an amount of money once he had married the daughter-in-law. Now, unfortunately, the father-in-law passed away, and then the question arose as to who can enforce that contract. The court held the contract can only be enforced by either of the two fathers, or if they pass away, their estates. The contract cannot be enforced by the son, because the son is a third party. Even though he's a beneficiary, even though he's supposed to receive money under the contract, he is a third party, and third parties cannot sue under a contract to which they are not privy. So again, very simple, very straightforward in terms of its the general principle that this entails. There are a few sort of special circumstances or things that we need to think about a bit more. One that was asked about previously, the idea of a collateral contract. So as I said earlier, a collateral contract means there's a contract on the side, usually a contract that induces the main contract. So essentially we have two contracts. Now, we have a case for this, Mahncke, Peer and Dettel Products. How does this relate to privity? Well, it does in this way. So Mahncke Peer was a company that ran a pier, the sort of thing sticking out from the sea. For instance, in the UK, piers are often used for restaurants and amusement parks. You get that in the US as well, and so on. Of course, a pier can just be for ships to dock. Anyway, Mahncke ran one of these piers. Now, as part of the normal sort of upkeep and maintenance, they wanted to paint the pier, have it painted nicely and done nicely. So they got a contractor to do that. Now, they had previously inquired with finding out which paint is going to survive sort of that rough environment with the seawater and so on. And Dettel was supposed to provide the paint that was going to last for some years. So Mahncke asked their contractor to use the Dettel paint, which they did. And then the Dettel paint only lasted for a few months and then it came off. So then Mahncke Peer tried to sue Dettel for basically supplying shoddy paint. The problem was that Mahncke Peer and Dettel did not have a contract, remember? Mahncke Peer had a contract with the contractor, the painters, and then the painters had a separate contract with Dettel by which they bought the paint. But because this was a scenario of a collateral contract, that means there was a second contract that induced the main contract. So the second contract was the contract which the court deemed to be a collateral contract between Mahncke Peer and Dettel Products, where Dettel Products said, we supply great paint that will survive for years, and in return, Mahncke Peer told its contractors to use Dettel Products. So Dettel Products then basically got the benefit of selling those paints. So that was the collateral contract, and the main contract was the one between Mahncke and the contractors, the painters. So the collateral contract was sufficient to make Dettel part of the contract, so Dettel could be sued directly by Mahncke, and you didn't have to go through the motions of privity, whereby if you applied strict privity, then without the collateral contract, then the painters would have had to have sued Dettel sort of on behalf of Mahncke Peer. So you overcome that by way of collateral contracts. The other question we had in relation to privity was the question of the officious bystander test. So I saw that someone talks about Southern Foundries and Shore Law. So I didn't use this case on the course, so I don't want to complicate matters, but the case, of course, refers and relates to the Moorcock, which we did discuss at great length. So let me just discuss this idea of the officious bystander test in relation to the Moorcock. When you have a term, contractual term, so we've moved on now to the actual terms, moved on from privity. If you have a contractual term in your contract, the best way to deal with it is just to have it in there, to specifically, expressly agree the term. Then there's going to be no issues. But sometimes parties didn't discuss something, didn't mention something, and then the question arises whether that something, once it becomes a problem, was part of the contract or not. So the only way it can become part of the contract is by implication, if it was implied into the contract. So the court set out the rules of implied terms in various cases, but we used the Moorcock as kind of our anchor case, as our main case. So in the Moorcock, there was a ship that was going to use a pier, a jetty, to unload. And there was a contract between the ship's owners and the jetty's owners for the use of the pier. Now, the contract didn't mention what would happen if the ship, so the parties hadn't agreed or talked about who would be responsible if the ship got damaged or anything like that. Now, as it turns out, the pier was not safe to use because when the ship docked, there was high tide, but during the docking, the tide went out and the ship hit the bottom of the channel and got damaged. So then the parties hadn't talked about that at all. So there was no express terms on this particular issue. So the court said there was in fact an implied term, which is what the owners of the Moorcock had argued. And the implied term was that if the jetty owners, the pier owners, let out their pier to a ship's owners, then they imply that it is safe to do so. It is implied that it is safe to use the pier. That's an implied term. So this is where we then get to this officious bystander test, or sometimes it's called the business efficiency test, which it was in the Moorcock. Essentially, it's the same thing. It's just slightly sort of different ways of referring to it. What it is if back when the parties were agreeing, so when the owners of the Moorcock, the owners of the ship, and the owners of the jetty were negotiating the contract to use the jetty to unload, if there had been an officious bystander, a third party, or we could also say a reasonable person in the room, say a fly on the wall, just kind of listening in on the situation, just thinking hypothetically, what would that person have thought? What would that person have determined? And if that person had determined that simply by way of, it goes without saying, that was the phrase used. So if the person had thought, well, it goes without saying that even though the parties didn't talk about it, that they had agreed that the pier was safe to use. If an officious bystander had come to that conclusion, if you kind of go back in time and pretend there was one there, then there is an implied term. So what we're saying, in other words, is would a reasonable person, going back in time, looking at the parties negotiating, would that reasonable person have determined that the parties, without saying it, had agreed to something? But it really, in order to satisfy that test, it really has to be so obvious that what you agree to is so obvious that you don't even have to say it. So the only reason, in other words, the only reason why it's not mentioned in the contract, why it's not written down, is just because it's totally obvious. So it is totally obvious that if you're going to hire a pier to use it to unload your ship, that the other side guarantees that the pier is safe to use. You don't have to write that down specifically. So that's an example of an implied term. That's an example of the officious bystander test. And yeah. So Southern Foundries was mentioned. We also have Cunliffe-Owen. There's different cases you can use for that. Let me just go through the list to see that I've covered the various topics. I see there's another question on privity. So let's just bounce back for a moment to privity again. There was a question about the agency. So on privity so far we've talked about a lot of things. We talked about collateral contracts. Agency, what's that? Well, we already talked about agency in respect of the Euromedon. So agency basically means that party A and B agree a contract. And the agency part means that if certain criteria are met, party B may be an agent for party C, so that there's not only a contract between A and B, but there's also a contract between A and C by way of agency. So that, in a sentence, is what agency means. Now, our main case that established this was Adler Dickinson de Himalaya. Obviously, we also had Scruttons and Midland Silicones, where this was sort of expanded on or spelled out by way of a test. And then we had the Euromedon, which we just discussed, where it was literally applied in the real world and successfully applied. In order for a party to be an agent, so in order for party B to be an agent for party C, in order for A and C to have a contract, you basically just need to have 4 things in place. First of all, the contract between A and B has to mention C. C has to be mentioned there somewhere. Now, C doesn't have to be mentioned by name, but it has to be mentioned by class or group. So in the shipping case, if the shipping company wanted to employ a stevedore and it wanted the stevedore to be part of the contract, it doesn't have to say, we are agents for XYZ company or for ABC company. All it has to say is that we are agents for any stevedores, like a group of types of people, a group of types of companies. So, but you have to mention the third party, number 1, if only by group. Number 2, you have to mention the word agency. So it has to be clear that B is acting as an agent. Third, the other side, C, the third party, has to agree to the agency. They have to agree to, they have to have given authority to the agent to act as an agent. And then fourth, and this was the point that was discussed in New Zealand shipping and in the Euromedon, is that consideration cannot be a problem. So there must be consideration. So there's different ways of looking at it. We looked at it earlier when we looked at the Euromedon by saying, well, one act, unloading the ship, can pay for 2 separate contracts. It can pay for the contract that pays for the actual unloading, plus it can pay for the contract where you don't get sued, the promise not to get sued. That's what we discussed earlier. Another way of looking at it, which is equally valid, is the consideration that is provided by the third party vis-a-vis the first party. So what A gives C the right, and when we use agency, whether it's Scrutons or whether it's the Himalaya or whether it's Euromedon, so the first party, party A, promises not to sue. That's their promise. So party C, what do they provide? So in the Euromedon we said, well, what they provide is they unload the ship. Okay, that's the consideration. There's another way of looking at it, equally valid, which is what they provide is they provide that they become suable. They suffer a detriment. If party C is in fact a party to the contract between A and B, so suddenly there's also a contract between A and C. If there's a contract between A and C, that not only means that A has certain detriments, but it also means that the mere fact that there is a contract means that C can now be sued in contract, which they can't be, obviously, if there's no contract. So the mere fact that someone has made themselves suable is consideration, because it's a detriment. Okay, so that's, in a nutshell, the idea of agency. Now, we have a few other questions. Parker, okay, let's get to that. So we talked about privity, we talked about contractual clauses, implied and express. Let's talk about exclusion clauses. So exclusion clauses are this is our last topic. Exclusion clauses are very specific types of contractual clauses. What they seek is to limit liability in some way. So we had that already, the Euromedon, New Zealand shipping status weight. You can only, if there's any problem, you can only sue for 1 year. Okay, that excludes suing beyond 1 year. So it's an exclusion clause. A very typical type of exclusion clause, which we had in Adler and Dickinson, the Himalaya, is if there's any problem, the maximum that we will pay in compensation is $500, $1,000, whatever. So these are all very normal clauses. Many contracts feature them. The question with exclusion clauses, the kind of the test, the checklist we have to go through is twofold. First, we have to see whether the exclusion clause has been incorporated. In other words, is it part of the contract? Secondly, we have to check whether the exclusion clause is clear enough and wide enough. All right, so Parker, the question I was asked was about Parker and Chapelton and how that's different, how Parker and Chapelton are different. So this has all got to do with incorporation. So incorporation generally is very simple if it's express, because it follows the same rules as general contractual terms. So if you have a contract and it mentions an exclusion clause and both parties sign, then they have expressly agreed to that. That's Lestrange Graco. Basically, you sign, you're bound. Very simple. No big need for a discussion there. It gets a bit more difficult if you haven't signed. So this happens when you buy a movie ticket, or if you go on a bus. You haven't signed anything, you just get a ticket. And then the question arises as to whether or not that is still a valid exclusion clause, even though the person against whom it is applied never signed it. And the basic rule is one that we know from Parker, again, a kind of leading landmark case on this, Parker and Southeastern Railway. There has to be reasonable notice. So if the party against whom the exclusion clause is applied, if that party has not signed, then they're only bound if reasonable notice was given. What is reasonable notice? Well, in Parker, remember, Parker was given a ticket, which was a receipt for a left bag at a left baggage facility, and the receipt said on one side, we limit ourselves to only £10 in case the bag is lost or damaged in compensation. On the other side, it said C or relief, C on the other, turnover for terms and conditions. So both sides of the tickets said something that pointed the recipient, Mr. Parker, to the exclusion clause. So the court said that's reasonable. Okay, that's reasonable notice. In Chapelton, there was a difference because, remember, Chapelton was the guy who rented a deck chair at a beach, and he rented it from a council, the urban council there. And what he did was he picked up the deck chair, which at the place you're supposed to pick it up, and he paid the money. I think it was like some amount for like 3 hours of deck chair use or whatever. And then he was given a receipt. And the receipt said that the council was not responsible for any damage, for any injury, and so on and so forth. And because it was one of these kind of flimsy deck chairs, what happened was that it snapped, and Mr. Chapelton got injured. So the council said, well, we're not going to pay any compensation because we excluded any compensation for any liability, including injuries. And the difference between Parker and Chapelton is very simple. When Mr. Chapelton got his receipt, the contract had already been formed because the contract was deck chair in return for money, and he had handed over the money and the money was taken. Then the contract is formed at that point. If you want to incorporate terms into a contract after the contract is formed, you have to have a new contract, which there wasn't. So you cannot incorporate terms into a contract after the contract has already been formed. That's very simple. In Parker, the contract, when Mr. Parker took the ticket, the contract was not fully formed yet. Because when he took the ticket, there was a chance for him to have a look at the ticket and say, oh, you only give £10 compensation? No, this is too risky for me. Can I have my bag back again? No contract. Okay? So there was a moment in time. Now, you can argue whether that's like 5 seconds or 10 seconds or perhaps even something like a minute or so, but there is a bit of time there for Mr. Parker to decide whether he wants to go ahead or not. In Mr. Chapelton's case, there is no such time because the contract was already fully formed. So that's the difference between those two. Okay, next question is, we basically covered all our topics now. So let me just try and go through all the questions that we still have to make sure so we're probably going to bounce around a bit now between topics to make sure we've covered everything. So the next question is whether if you say something is subject to contract, does that then mean it is not going to, you're not bound, you're not legally bound? And the answer is yes, that's true. So any contract that says this contract is subject to contract, well, it wouldn't say this contract, it would say this preliminary agreement or something like that is subject to contract. Well, what you're essentially saying is that there is no contract. We're yet to agree to a contract. So that would then not be a contract. Okay, the next question is between privity and estoppel. I'm not sure I know what is meant by that question, the relationship between those two. Those are sort of quite different. So I guess the answer would be if you're not privy to a contract, you cannot claim estoppel. You need to have privity. You need to be a party. You need to be either party A or B in order to be able to rely on estoppel. Okay. Next question is Thornton and shoe lane parking. Okay, remember Thornton was the so we're basically back with sort of Parker and Chapelton and so on. Now we've got another question about Chapelton. So Chapelton, just to recap, maybe for those of you who just arrived, Chapelton is a guy rents a deck chair. So what happens is you go to a little stand at the beach and you pick up your deck chair and you pay the money for the deck chair and the money is taken. At that point in time, you have the promise, which is to get the deck chair, and the consideration, which is the money, and they're exchanged and the contract is formed. There is a contract at that moment in time. If then after, another 5-10 seconds or whatever, the deck chair attendant, the one who took the money, gives you a receipt, and the receipt has some terms on it, those terms cannot be part of the contract because the contract has already been formed at the point in time when you get the receipt. It's too late. It's simply too late. So the way of avoiding any problems, if you want to incorporate those, if you're the company or the council that's renting out those deck chairs, what you do is you put a big sign next to the deck chair saying, use at your own risk, the council doesn't assume any responsibility, that sort of thing. But there was no such sign. So the receipt was too late because the contract was already formed. Now, this ties in nicely with Thornton and shoe lane parking. So Thornton is a great case, by the way. So in Thornton and shoe lane parking, a guy drives up to a machine to get to basically get access to a car park. And so what he does is, there's two ways of doing it. It doesn't really matter for all purposes. So you can put in some money and then you take out a ticket, or you press a button and take out a ticket. But it makes no difference for all purposes. So this chap put in some money and then he took out a ticket. Now, the ticket didn't say anything, and he drove inside. And inside the car park, near where he parked, was a big sign saying that the car park was not responsible for any injuries, loss, damage, that sort of thing. The guy got back and after a few hours and then got injured. And the question was whether, Mr. Thornton, the question was whether the exclusion clause, which the car park had posted inside the car park, was validly incorporated. And the answer was it was not. Because whichever way we look at the interaction at the machine, and we'll come back to that in a moment, but whichever way we look at it, at some point, when the interaction with the machine was done, the contract was formed. There was a contract. Now, if you then proceed into the car park, and then inside the car park you see a sign, again, it's too late. It's just like Chapelton, it's too late. The notice came too late. You cannot incorporate something after the contract is already formed. This is the reason why every car park of that nature, with these automatic machines that you enter, always has a big sign right at that machine. Just have a look next time when you enter any kind of car park with that sort of a machine or gate. There's always going to be a big sign saying these are the terms and conditions, so that there's no problem with incorporation, because you would have been made aware of these things before the contract was formed. That's the reason why. Now, a little sort of aside story on Thornton and shoe lane parking is in respect of when is the contract actually formed. As we said, the exact timing doesn't matter for the purposes of Thornton, because the sign which was inside the car park is definitely too late. But what if, for instance, just hypothetically, the ticket that Mr. Thornton got from the machine had stated the terms and conditions? Would that have been too late? Now, in the views of the court in Thornton and shoe lane parking, that would have been too late. But that's really an offer and acceptance issue, because the court held that if it's an automated machine, the offer is the fact that there's a machine there willing to take the... that's the invitation to treat. The fact that there's a machine there that's willing to have you as someone parking the car. The offer is when you put in the money or press the button. The acceptance is when the machine pushes out the ticket. That's acceptance. That's different from Parker. Why is it different? It's only different because it's a machine. The machine puts out the money, it puts out the ticket. the contract is formed, because you can't interact with the machine. You can't say, oh, I changed my mind, or I don't like this, or whatever. You're stuck, okay? The contract is accepted, the ticket is there. You have to take it, you have to proceed. In Parker, because it's a human being you're interacting with, the sequence is just slightly different. In Parker, the acceptance is not the giving of the ticket, the acceptance is taking of the ticket, which then includes having a look at the ticket, seeing whether it imposes any obligations that you don't like. Essentially, because in Parker, because you're acting with a human being, interacting with a human being, you can still say, oh no, I don't like this, I don't like these terms, or whatever, and then you can still say, no, I don't want to park here, or I don't want to leave my bag here, or whatever. If it's a machine, you don't get to say that. So just a slight sort of difference in terms of the timing, but in either case, the main point in respect of exclusion clauses is you have to incorporate the clause before or at the time the contract is formed, never after. Okay, let me just go through one more time to see that we've covered all the questions. So we had, New Zealand shipping, probably supple. Yeah, I think that basically covers it in terms of the questions that you asked here. The questions that I was asked earlier were about New Zealand shipping, which we discussed. So I hope this was helpful to you in some way. Obviously you are very welcome to still send me questions. You can email me questions. Still got a bit of time to go, and I'll try and answer as best as possible. But I guess for now, if there's no more questions, we will end the session. And thanks very much for your interest. I hope it was useful to you. And yeah, good luck and take care. See you.